Hi friends, good morning. Welcome to Shankaran AI Study Circle. This is Dr. Harinath Reddy, Director of the Institute. Today in this particular video, we will discuss about advisory or consultative jurisdiction of the Supreme Court under Article 143. So under Article 143, advisory jurisdiction, advisory or consultative. Article 143 of the Indian Constitution deals with advisory jurisdiction or consultative jurisdiction of the Supreme Court. So it is under Article 143, the President of India can refer any question of law or question of fact which has public importance. Here question of law means a question which is decided on the basis of the legal principles. Question of fact means a question which is decided on the basis of the fact and the evidences. So any question of law or any question of fact which is of public importance can be referred to the Supreme Court by the Indian President under Article 143 for the opinion of the Supreme Court. Under Article 143 Clause 1. So on a question of law or a question of fact which has got public importance, the President can refer a question of law or a question of fact which has public importance to the Supreme Court for its opinion under Article 143 Clause 1. Here remember, in Article 143 Clause 1, the word used is may. May means may not be also. So on a question of fact or a question of law which has got public importance, if it is referred to the Supreme Court by the President under Article 143, it is not binding on the Supreme Court. To give its opinion, because the word used is may in Article 143 Clause 1. So the Supreme Court may refuse to give its opinion. So which means under Article 143 Clause 1, on a question of law or a question of fact of public importance, if a matter is referred to the Supreme Court by the President, then it is for the Supreme Court whether to give the opinion or not to give the opinion. It is not binding on the Supreme Court to give its opinion. It is not compulsory for the Supreme Court to give its opinion. The Supreme Court can give the opinion or may reject giving the opinion. This is because the word used in Article 143 is may and it is not shall. And remember, advisory jurisdiction of the Supreme Court, this is borrowed from Canadian Constitution. In addition to this, the advisory jurisdiction of the Supreme Court in India under Article 143, it is also borrowed from Government of India Act 1935. So under Government of India Act 1935, the federal court has the power of advisory jurisdiction to give its advice to the Governor General when any question of law or fact of public importance is referred to the Governor General. In other words, advisory jurisdiction of the Supreme Court under Article 143, it has been taken from the Canadian Constitution as well as Government of India Act 1935, In addition to this, under Article 143 Clause 2, remember this Article 143 Clause 2, in Article 143 Clause 2, there is reference to Article 131. And you have to read Article 143 Clause 2 has to be read with Article 131 and also along with Article 373. Along with Article 363. So what is the relationship between Article 143 Clause 2, Article 131, Article 363 Clause 1? Remember, Article 131 of the Indian Supreme Court deals with the original jurisdiction of the Supreme Court. And remember, this is exclusive original jurisdiction of the Supreme Court. Exclusive in the sense, this jurisdiction is available only to the Supreme Court, not to the High Courts. That is exclusive. What is original? Any matter, if it can be taken to the Supreme Court straight away without any appeal, then it is original. So if there are disputes between the center and the states, between the states, among the states, these issues are resolved by the Supreme Court under Article 131 through its exclusive original jurisdiction. But Article 131 makes a mention of certain pre-constitutional treaties which were signed by the rulers of the Indian princely states. A pre-constitution treaty is a treaty which is signed before the commencement of the constitution. So if there is any pre-constitution treaty signed by the ruler of the Indian princely states which continues to remain in operation even after the commencement of the Indian constitution, then with respect to the pre-constitution treaties which are under operation even after the commencement of the constitution, the jurisdiction of the Supreme Court is taken away. So with respect to the pre-constitution treaties which are under operation after the commencement of the constitution, the Supreme Court will not have jurisdiction. But under Article 143 Clause 2, with respect to a pre-constitution treaty, the President can seek the opinion of the Supreme Court under Article 143 Clause 2. So in other words, here you should remember, Indian Supreme Court has got advisory jurisdiction with respect to the pre-constitution treaties. It doesn't have normal adjudicatory powers with respect to pre-constitution treaties. That's the point which you should make. Article 131 says, Article 131, which deals with the exclusive original jurisdiction of the Supreme Court, does not allow the Supreme Court to entertain the pre-constitution treaties. But Article 143 Clause 2 allows the Supreme Court to give its opinion to the President on pre-constitutional treaties under Article 143 Clause 2. This is the difference between Article 131 and Article 143 Clause 2. Article 131 excludes the pre-constitutional treaties from the purview of the Supreme Court. But under Article 143 Clause 2, the Supreme Court can give its opinion on pre-constitutional treaties if referred to the Supreme Court by the President under Article 143 Clause 2. And this is explained by Article 363. Article 363 Clause 1 says, pre-constitutional treaties signed by the ruler of an Indian princely state, even if they are in operation even after the commencement of the constitution, on such issues, the opinion of the Supreme Court can be taken by the President under Article 143 Clause 2. That's what 363 Clause 1 says. So here you should read Article 143 Clause 2 in relation with 131 and 363 Clause 1. In addition to this, in Article 143 Clause 2, the word used is a shall. Please remember, there is a difference between Article 143 Clause 1 and Article 143 class 2. Article 143 class 1, it deals with a question of law or a question of fact of public importance. It doesn't deal with pre-constitutional treaties. But Article 143 class 2, it deals with the pre-constitutional treaties. It deals with the pre-constitutional treaties, not with a question of law or a question of fact. This is one difference. The second difference is, in Article 143 class 1, the word used is may, which means any reference made to the President, any reference made by the President to the Supreme Court under Article 143 class 1 with respect to a question of law or a question of fact of public importance, it is for the Supreme Court whether to give the opinion or it can also reject giving the opinion. But under Article 143 class 2, the word used is shall. So if a pre-constitutional treatise, with respect to pre-constitutional treatise, if a reference is made by the President to the Supreme Court of India to give its opinion, then the Supreme Court is bound. It is bound to give the opinion. It must give the opinion. But here again, there is an exception. The Supreme Court itself said, if there is a valid reason, even under Article 143 class 2, any reference made by the President to the Supreme Court with respect to a pre-constitutional treaty for a valid reason, the Supreme Court may reject giving the opinion. Ordinarily, the Supreme Court under Article 143 class 2 with respect to a pre-constitutional treaty, if a reference is made by the President to the Supreme Court, ordinarily the Supreme Court is bound to give the opinion because the word is used is shall. But if there is a compelling reason, if there is a valid reason why the opinion cannot be given, the Supreme Court can reject giving the opinion. So that is the difference between Article 143 class 1, Article 143 class 2. Article 143 class 1, the word used is may. Article 143 class 2, the word used is shall. Article 143 class 1 deals with a question of law or question of fact of public importance. Article 143 class 2 deals with a pre-constitutional treaty. Whether it is Article 143 class 1 or whether it is of Article 143 class 2, the opinion given by the Supreme Court is not binding on the President, which means the President is not bound to follow the order. The President is not bound to implement the order. In addition to this, the advice given by the Supreme Court under Article 143 is not a judgment, it is not a decree, it is not an order. It is not an order. So it is also not binding on the subordinate courts in this country. It has only some weight, but it is not binding on the President. It is not binding on the subordinate courts. That's one important point. Then, so far under Article 143, 15 references have been made to the Supreme Court. So far under Article 143, 15 references have been made to the Supreme Court. So this we can see. Advisory jurisdiction of the Supreme Court. Yeah, as I told you just earlier, this is borrowed from Canadian Constitution. It is not only that, in addition to Canadian Constitution, we also have borrowed the advisory jurisdiction of the present Supreme Court from the Government of India Act. Government of India Act 1935, Section 213 Class 1. Section 213 Class 1 confers such a power on the Federal Court established under the Government of India Act 1935 in relation to Governor General of India. And this is borrowed into the Indian Constitution from Government of India Act 1935. Section 213 Class 1 of the Government of India Act 1935 also deals with the advisory jurisdiction of the Federal Court in relation to the Governor General of India. And in addition to this, so I told you a question of fact must be answered by reference to facts and evidence, and as well as inferences arising from those facts. But a question of law must be answered by applying relevant legal principles. And remember, as I told you, under Article 143, the opinion given by the Supreme Court, it is not binding on the President. The opinion is only advisory, which the President is free to follow or not to follow. This was held in the Keshav Singh's case of 1965. The opinion tendered by the Supreme Court under Article 143, it is not binding on the President. The President is free whether to follow it or not to follow it. And then the first reference under Article 143 was made in the Delhi Laws case 1951. So the first presidential reference to the Supreme Court under Article 143 was done in 1951 with respect to Delhi Laws case. Delhi Laws case. And then even in 2002, there was a controversy between the Election Commission and Government of India on elections in Gujarat. Post Godhra violence in Gujarat, Election Commission of India felt that the situation is not conducive for conduct of elections in Gujarat, so there is a need to postpone the elections in Gujarat. But Government of India wanted the elections to be conducted in time in Gujarat. On that issue, there was a difference of opinion between Election Commission of India and also Government of India. On this matter, there is a reference to the Supreme Court for the opinion of the Supreme Court. That's one important case. And in this case, it is related to the interpretation of Article 324, the powers of the Election Commission of India under Article 324, and Article 174. Article 174, which deals with the tenure of the state legislature and the meetings of the state legislature. And then Article 143 is not part of administration of justice. Article 143 is an exception compared to the other articles related to Supreme Court, because Article 143, it empowers the Supreme Court to give advice to the President when sought, and that's why it is not part of administration of justice. It is not part of administration of justice. So here, as I told you earlier, Article 143 Clause 1, a question of law or fact, if at any time it appears to the President that a question of law or fact has arisen or is likely to arise, which is of such a nature and of such public importance that it is important to obtain the opinion of the Supreme Court upon it, he may refer the question to the court for consideration, and the court may, so here the word used is may, and the court may, after such hearing as it thinks fit, report to the President its opinion thereon. Then under Article 143 Clause 2, I told you, under Article 143 Clause 2, the President can ask the advice of the Supreme Court with respect to a pre-constitutional treaty on which ideally the Supreme Court doesn't have a jurisdiction. The Supreme Court doesn't have jurisdiction over pre-constitutional treaties, but it has advisory jurisdiction. It can give advice, it can give opinion on pre-constitutional treaties under Article 143 Clause 2 if referred to the Supreme Court by the President. So that's why in Kerala Education Bill 1957, in this case, the Supreme Court held the view. What is the view? In Article 143 Clause 1, the word used is may. So the Supreme Court may give its opinion or may reject giving its opinion. But under Article 143 Clause 2, as the word used is a shall, the President must give the opinion when referred to the Supreme Court with respect to a pre-constitution treaty. But subsequently in other cases, the Supreme Court said, for valid reasons, even under Article 143 Clause 2, despite using the word shall, the Supreme Court may reject giving its opinion for a valid reason. And as I told you, Article 143 does not deal with the jurisdiction of the Supreme Court, but it is a power of the President. It does not refer to any adjudication at all, but it deals with consultation. It deals with consultation. In addition to this, Article 137 of the Indian Constitution, Article 137 of the Indian Supreme Court, Article 137 of the Indian Constitution empowers the Indian Supreme Court to review, to reconsider its own judgments. So with respect to this, can Article 143 be used? Can Article 143 be used to reconsider the judgments given by the Supreme Court? So in this case, that is in a Kaveri Water Disputes Tribunal 1992, in that presidential reference case, the Supreme Court clearly said any judgment given by the Supreme Court can be reviewed, can be reconsidered only under Article 137. Article 143 cannot be used for reviewing the judgments given by the Supreme Court. That's one important observation made by the Supreme Court. And there is one more presidential reference which was made to the Supreme Court by the President in 1979, and this is related to whether the Parliament has power to create special courts for dealing with emergency offences. In this case, the Supreme Court held the Parliament does enjoy such powers, but with safeguards. That is Special Courts Bill Case 1979. So this case was decided by a 7-judge bench of the Supreme Court by 6:1 majority that Parliament has the power to establish special courts for a trial of emergency offences subject to certain procedural safeguards. Then Kaveri Disputes Tribunal, this is one more presidential reference which went to the Supreme Court. Here the issue is Kaveri river waters is a matter of dispute between Karnataka and Tamil Nadu. So when a tribunal was appointed for resolving the disputes with respect to sharing of Kaveri river waters, the tribunal has given an interim award, an interim decision asking Karnataka to release waters to the state of Tamil Nadu. But Karnataka state government passed an ordinance not to implement the award given by the tribunal. Then Tamil Nadu, on the request of the Tamil Nadu, the union government referred this matter to the Supreme Court under Article 143. The Supreme Court said that the decision of the Karnataka government is null and void and it is unconstitutional. Court held that the Karnataka ordinance was unconstitutional as it is against the decision of the tribunal given by the Kaveri River Water Disputes Tribunal, which was appointed under Interstate River Water Disputes Act 1956. And this law was enacted under Article 262 of the Indian Constitution. The ordinance is also against the principles of the rule of law as it has assumed the role of a judge in its own cause. The ordinance is also against the principles of the rule of law because it has assumed the role of a judge in its own cause. Even this is not permitted. And this is one important case, Ismail Faruqi versus Union of India, related to Babri Masjid. So before the building of Babri Masjid Mosque in this place, whether there was a temple before that is the question asked to the Supreme Court by the presidential reference. And the Supreme Court, in this case, Ismail Faruqi versus Union of India, 1994, it rejected giving its opinion on this particular issue. The reason given by the Supreme Court is Indian Constitution is opposed to secularism and this reference favored one religious community and therefore does not require to be answered. Does not require to be answered. So this I have told. Article 143 clause 2 deals with the cases in which the President may refer a dispute to the Supreme Court with respect to a pre-constitution treaty. So Article 363 clause 1 excludes disputes arising out of agreements to which the ruler of an Indian state was a party from the original jurisdiction of the Supreme Court. But it is while it is optional to the Supreme Court to answer a reference made under clause 1, it is obligatory to answer a reference made under clause 2. This I have explained. Article 143 clause 1, the word used is may. under Article 143 Clause 2, the word used is shall. See the list of presidential references. So far, 15 presidential references were made to the Supreme Court under Article 143. So these presidential references were on these following matters. The first reference, Delhi Laws Act enacted in 1951. The second one, Kerala Education Bill in 1958. The third one, Berubari Union in 1960. The fourth one, Sea Customs Act in 1963. Fifth one, Keshav Singh's case relating to the privileges of the legislature in 1964. Sixth one, Presidential Election in 1974. Seventh one, Special Courts Bill in 1978. Eighth one, Jammu and Kashmir Resettlement Act in 1982. Ninth one, Kaveri Water Disputes Tribunal in 1992. 10th one, Rama Janmabhoomi case in 1993. 11th one, consultation process to be adopted by the Chief Justice of India in 1998. Legislative competence of the center and the states on the subject of natural gas and liquefied natural gas in 2001. 13th one, the constitutional validity of the Election Commission's decision on postponing the Gujarat Assembly elections in 2002. 14th one, Punjab Termination of Agreements Act in 2004. The 15th one, 2G spectrum case verdict and the mandatory auctioning of natural resources across all sectors in 2012. So these are the 15 presidential references which were made before the Supreme Court by the Indian President under Article 143. That's it about the advisory jurisdiction of the Supreme Court. Thank you.